Intellectual property by Group 4. Our group members. Defenses to copyright infringement.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Ahmad Al-Halabi Mahalidi, IL201017. And for today, I would like to present my part, which is the introduction. And the next part of mine, which will be read later. So for my first part, which is the introduction, what is copyright? Copyright is infringed by any person who does or causes any person to do without the license of the owner of the copyright. An act the doing of which is controlled by copyright under the Act of Copyright Act 1987. Next, what is infringement of copyright? Infringement copyright is infringed by any person who, without the consent of or license of the owner of the copyright, imports an article into Malaysia for the purpose of first, selling, letting for hire or by way of trade, offering or exposing for sale or hire the article. Number 2, distributing the article for the purpose of trade or for any other purpose to an extent that it will affect prejudicially the owner of the copyright. And the last one, by way of trade, exhibiting the article in public. For the next part, which is defenses to copyright infringement, defenses to copyright infringement under Section 13, subsection 2 of the Copyright Act 1987 provides defenses to infringement action for the following. First of all, fair dealing for purposes of research, private study, criticism, review of the reporting of news or current events, provided that it is accompanied by an acknowledgement of the title of the work and its authorship, except that no acknowledgement is required in connection with the reporting of news of current events by means of sound recording, film, or broadcast. Next, doing of any act by way of parody, pastiche, or caricature. Next, incidental inclusion in the film or broadcast of any artistic work situated in a place where it can be viewed by the public. Next, reproduction and distribution of copies of any artistic work permanently situated in a place where it can be viewed by the public. Last but not least, incidental inclusion of a work in an artistic work, sound recording, film, or broadcast. Next is when we are talking about non-statutory defenses. They include where the nature of the work itself is such that it should not be protected on the grounds of public policy, and also where the unauthorized public disclosure of the copyright material is in the public interest. That's all from me. Thank you.
Under Section 41 of Copyright Act 1987, penalize the following activities relating to copyright infringement. A. Making of any infringing copy for sale or hire. B. Selling, letting for hire or by way of trade or exposing or offering for sale or hire any infringing copy. C. Distribution of infringing copies. D. The possession, otherwise than for private and domestic use, of any infringing copy. E. By way of trade exhibition in public of any infringing copy. F. Importation into Malaysia of any infringing copy other than for private and domestic use. G. Making or the possession of any contrivance used or intended to be used for the purpose of making infringing copies. H. Circumvention or authorization of the circumvention of any effective technological measure. Manufacture, importation, or sale of any technology or device for the purpose of the circumvention of a technological protection measure. I. Unauthorized removal or alteration of any electronic rights management information. J. Authorized distribution, importation for distribution or communication to the public of works and copies of work. Example related case law. Rogers vs. Coons. Art Rogers, a professional photographer, took a black and white photo of a man and a woman with their arm full of puppies. The photograph was simply entitled Puppies and was used on greeting cards and other generic merchandise. Jeff Koons, an internationally known artist, found a picture on a postcard and wanted to make a sculpture based on the photograph for an art show on the theme of banality of everyday item. After removing the copyright label from the postcard, he gave it to his assistant with instructions on how to model the sculpture. He asked that as much detail be copied as possible. Thus, Koons sold 3 of them for a total of $3,067. Upon discovering that his picture had been copied, Rogers sued Koons and the Sonar Band Gallery for copyright infringement. Koons admitted to having copied the image internationally, but attempted to claim fair use by parody. decision of the court found both substantial similarity and that Kunz had access to the picture. The similarity was so close that the average lay person would recognize the copying, a measure for evaluation. Thus, the sculpture was found to be a copy of the work by Rogers. On the issue of fair use, the court rejected the parody argument. To summarize, the purpose of copyright is to protect the right of the creator and provide the incentive and economic benefit to the creator. The scope of copyright extends to literary or artistic works which demand creativity, including database and computer software. The registration of work is not necessary to be eligible for copyright. However, it is often advised to register the work because it serves as evidence in the court. If a person infringes the copyrighted work of someone, then he will be liable for both the criminal liabilities and civil liabilities. Thus, there are certain exceptions to the copyright infringement. Therefore, it is always advised to produce the original work and not to use someone's copyright work without permission.
Moral rights under the Copyright Act 1987.
Assalamualaikum warahmatullahi wabarakatuh. My name is Razman Zuramikar Malik. My method number is DIL191013. I will present the introduction to moral rights under the Copyright Act 1987. The Copyright Act 1987 provides for the protection of two types of moral rights, which are spelled out in Section 25 of the Act. Section 25 sub 2, where the copyright subsists in a work, no person may, without the consent of the author, do or authorize doing of any of the following two acts. There are two types of moral rights under the Copyright Act 1987. The first is right of paternity. Right of paternity is the presentation of the work by any means whatsoever without identifying the author or under a name other than that of the author. Pursuant to Section 25 sub 1, the word's name includes initial or monograms. Second is right of integrity. The distortion, mutilation or other modification of the work if the distortion, mutilation or modification significantly alters the work and is such that it might reasonably be regarded as adversely affecting the author's honor or reputation. Next, right of paternity, which means right to be identified as author. The right to be identified as the author of a work is a fundamental moral right because it is through this right that the public knows who the author is. If the public does not know the identity of the author, then the second type of moral right, which relates to the distortion or mutilation of a work in a manner that puts the author in an unfavorable light, is devoid of meaning. Section 25 sub 2 sub A lays down to two aspects of this right to be identified as author. There are two example cases, which the first is Syed Ahmad Jamal against Datuk Bandar Kuala Lumpur. The second is English case in Hyperion Records Limited against Sawkins. Finally, right of integrity. The second category of moral rights recognized under the Copyright Act 1987 is the right of integrity, which is embodied in Section 25 sub 2 sub B of the Act. This section prevents anyone without the consent of the author to distort, mutilate or modify a work if to do so would significantly alter the work and would reasonably be regarded as adversely affecting the author's honor or reputation. The distortion, mutilation or modification must significantly alter the work and in addition reasonably be regarded as having an adverse effect on the author's honor or reputation. In essence, this right of integrity is the right to object to the derogatory treatment of work or any part of it. The basis for the right of integrity is said to rest on the notion that a work embodies the author's personality and his integrity has to be protected. What acts would amount this distortion, mutilation and modification are not defined in the Act, and it would appear that the ordinary meanings assigned to those words would apply.
Assalamualaikum and hi, my name is Naili Masha and my matric number is DIL193042. So I will continue with right of assignee or licensee to make modification and infringement of moral rights. As there may be some circumstances where the assignee or licensee of the copyright wishes to commercially use the work but is unable to do so without making modifications to it. Therefore, Section 25 Subsection 3 of the Copyright Act allows the assignee or licensee to make limited modifications to the work. It provides that where an assignee, a licensee, or any other authorized person wishes to publish, reproduce, perform in public, or communicate to the public, he may make modifications to the work if it is reasonable to expect that. Besides, such authorized act could not take place without the modifications. Besides, Section 25 Subsection 3 provides that the subsection shall not be construed as authorizing a modification to a work, which will constitute a contravention of the moral rights in Section 25 Subsection 2. Therefore, it is clear that the modification permitted in Section 25 Subsection 3 are very limited in nature, as they must not in any way impact on the moral rights in a work. Next is infringement of moral rights. Any contravention or threatened contravention of a moral right is actionable by the author of the work or his personal representative as followed under Section 25 Subsection 5. Besides, such contravention can lead to the court awarding damages or by Section 25 Subsection 7 to the court ordering the offender to publish such correction in such manner as the court may direct. Furthermore, the damages are not confined to pecuniary losses, but may include damages to compensate for any injury to the plaintiff's feeling, dignity, or reputation caused by the defendant's behavior. Where the personal representative of an author recovers damages pursuant to any contravention of moral rights, any damages that are awarded shall devolve as part of the author's estate under Section 25 Subsection 6. Apart from the protection of moral rights granted under Section 25, it is possible for an author to rely on other mechanisms to protect his moral rights, which is through the law of contract. Besides, example case law related to this issue is Mohtar Haji Jamaluddin against Pustaka System Malaysia. That is all from me. Thank you. I will pass the presentation to the next presenter.
Assalamualaikum warahmatullahi wabarakatuh and selamat sejahtera. My name is Muhammad Ilham bin Azmi and entry number DIL20103. I will continue the presentation with another mechanism of protecting moral right, which is the law of passing off. So another mechanism of protecting moral right is through the law of passing off in the context of occur when a person who is not the author of a work claims that he is the author and therefore passes off the work of the actual author and his own word. An action for passing off will only lie if the author can show that he has some trending activity and therefore goodwill in his name which has been damaged by the act of passing off. If a word is dealt with a derogatory way, this might give rise to an action in defamation. Section 35 Section 8 provides that nothing in Section 25 shall derogate from any right of action or other remedy in proceeding instituted otherwise than by virtue of the section. Further, Section 25 Section 8 provides that in assessing the award of damages, any damages granted under Section 25 should be taken into account in assessing the damages to be granted in any other proceeding. For the conclusion, the moral right is residing in an original work are equally important to the ownership right of a work protected under the CA, which is the Copyright Act, where the owner of the copyright and the author are two different entitled to the copyright owner should be made aware that the author retain the moral right and refrain from carrying out any action which may have an effect of denigrating the integrity of the origin or of the original work and thereby undermining the author honor and reputation.
Defenses to infringement of patent.
For the introduction defenses to infringement of patent, Malaysian Patent Act 1983, Industrial Design Act 1996 and Trademark Act 2019 all contain provision under which a license of the registration owner may take action for infringement in their own name in certain preset circumstances. This provision reflects the commercial reality that an infringement may often impair a license as much, if not more, than the IP owner in terms of lost sale and market share versus the owner potential loss of royalty or other licensing income. Amongst others exclusion, the patent right do not extend to act done to make use, offer to sell or sell a patent invention solely for uses reasonable related to development and submission of information to the relevant authority which regulate the manufacture, use or sale of drugs. That's all for me. Thank you. I will pass to the next presenter.
Hi and Assalamualaikum to madam. My name is Nurul Anisha Adam Tifata and my metric number is DIL20142. So I'm going to present about the type of defenses. There are 4 defenses for the infringement of patent. So firstly is invalidity defense. The invalidity defense is one of the most commonly used defenses in a patent infringement lawsuit. It is also frequently the first defense employed. 2 goals may be achieved by using the invalidity defense, such as having the patent invalidated completely or partly and making the claims of the patent further limited or narrowed. Secondly is non-infringement defense. For the non-infringement defense, the all elements rule should be considered. Firstly, to find infringement of a product or a method based on a patent right necessitate that the product or method contains technical features identical or equivalent to all the technical features described in the claim of the patent. No infringement of the product or method can be found if one or more of these technical features in the claim of the patent is not identical or equivalent in the alleged infringing technical solution. Thirdly is pure art defense. According to the judicial interpretation of Supreme People's Court, if all the technical features which are alleged to fall into the scope of protection of a claim of a patent are identical to or are not substantively different from the corresponding technical features of an existing technical solution, the People's Court shall determine the technology implemented by the alleged infringer as an existing technology. So for the last defenses is pure use defense and legal source defense. Pure use defense and legal source defense are not so commonly used as the above 3 defenses. For pure use defense, if the defendant has made or used a product or a process, respectively, which fall in the protection scope of a patent, or has made necessary preparations for making such a product or using such a process prior to the date of application of the patent, the defendant may continue to make such product or use such a process within the original scope. This is not considered infringement of the patent.
Hi madam, I am Mainstream here. My metric number is DIL193032. Today I'm going to present you about the variables defined to an alleged infringer. There are 10 variable defense alleged infringer. Firstly, not an invention. The invalidity defense is one of the most commonly used defense in a patent infringement lawsuit. It is also frequently the first defense employed. 2 goals may achieve by using the invalidity defense, such as having the patents invalidated completely or partly and making the claims of the patent further limited, narrowed down in scope, or clarifying the protection scope of claims of the patents. The second one is not patentable. The alleged invention is not patentable under the Patent Act 1983. The third one is contrary to public policy. The performance of any act in respect of claimed invention would be contrary to public morality. The fourth one is not new. The alleged invention is not patentable because it is not new, as it has been anticipated by the prior art. Prior art is defined as everything disclosure to the public anywhere in the world by written publication, oral disclosure, or anywhere in other way, but before the priority date of the claim. The fifth one is no intentive step. The invention is always having regard to what was known or used before the priority date. The sixth one is no industrially applicable. The invention cannot be made or used in any kind of industry. Followed by the description or claim does not comply with the Patent Regulation 1986. The specification of ambiguous does not sufficiently and fairly describe the invention. The method by which is not to be performed does not disclose the best method known to the applicant for the patents and which they were entitled to be protection claim. Followed by no drawing. The drawings that necessarily for understanding of claim invention does not have been provided. Followed by the patentee to entitled to the right or to the patent does not belong to the person to whom the patent was granted. The last one, incomplete or incorrect information. False or incomplete information has been deliberately provided or caused to be provided to register when filling a request or substantive examination by a patentee or their agent. That's from me, madam. Thank you.
Assalamualaikum everyone, my name is Muhammad Irfan bin Umar Faizal, DRL193015, and today I will be presenting about the defenses to infringement of patent, specifically the cases involved. Firstly is about the infringement cases in technology industry of patent. Product development really overlaps across the different markets, and frequently ideas are so abstract that cases of ownership are too complex to understand. Here are a few famous patent cases from the tech world. Firstly is the Amazon tried to patent its one-click payment option. However, the court decided it was too obvious an idea to patent. Secondly is the file-sharing company Napster settled a lawsuit accusing it of unauthorized distribution of music. It later filed a bankruptcy. Thirdly, Nintendo was forced to pay a large sum to Tomita Technologies International Incorporation for its 3D gaming system technology.
Fourthly, Microsoft and Google dueled for 5 years over patent issues involving the Xbox gaming system and Motorola smartphones. Moving on is the example case law. Firstly is the Premier Products Co. Ltd. and Anor and Zamrud Fiber Industry M as the NBHD and Anor. Here, the case stated that the first plaintiff as patent owner and second plaintiff as its licensee sued the defendant for patent infringement. At trial, there were essentially 4 issues to be determined. Firstly is whether the first plaintiff was the rightful owner of the patent. Secondly, the locus standi of the second plaintiff to join in the proceedings. Thirdly, the validity of the patent. And lastly is the question of the infringement. Secondly, Fukuyama Automation as the NBHD and Ziyin Engineering as the NBHD and Anor. In this case, the Malaysian plaintiff claimed to be the patent owner by virtue of an assignment from the original Japanese applicant. The plaintiff's ownership of the patent by virtue of the purport assignment was challenged. Thirdly is about the question, what does the claimant have to establish in a patent infringement claim? A patent is infringed when a product or process falling within the scope of the protection of the patent is exploited without the patentee's consent. The burden of proof lies with the claimant. The standard of proof is the balance probabilities. To ascertain whether a product or process falls within the scope of protection of the patent, the Malaysian court applied the purposive construction approach when the ascertaining the scope of the claims in infringement proceedings. In cases where the alleged infringing product or process is a variant of the patented product or process, the court have applied the 3-stage test known as the improver questions established. The second question is that, do the court or government bodies deal with infringement? The answer, the court can hear invalidation and infringement proceedings together, but will usually hear the invalidation proceedings before the infringement proceedings. That's all from me. Thank you for listening.
So transfer to me, my name is Nur Aila Najah binti Muhammad Hisham, DIL193012. So I present about the conclusion of defense infringement of patent. The court will have to judge every case and figure out exactly what happened, how the patent is infringed, and in what circumstances. The exciting thing about this is that if the infringer is guilty, he will have to pay damages to the patent holder, either debt or royalties. This can include lost profits among others. Infringing parties will also have to cover the litigation fees, court filing fees, and everything related to this. Also, the patent owner is allowed to stop the infringing party from creating this product unless the patent is fully removed from the equation. In conclusion, patent infringement laws are designed to help protect patent owners that work very hard to innovate and create new technologies. Unfortunately, a lot of innovators deal with patent infringement, and that is why it is essential to find a good legal professional that will help with this. With the right help and assistance, you will have no problem dealing with a situation like this. It's vital to protect your work and your patent, and with such an approach, you will have no problem achieving the goal.
Action under Trademark Act 1976.
Under Trademark Act 1976, Malaysia has broad and comprehensive law for intellectual property protection in respect to both statutes and common law. The statute governing trademark law in Malaysia is the Trademarks Act 1976, which is the Act with its accompanying Trademarks Regulation 1983. The Act, which came into force in Malaysia on September 1st, 1983, was amended in 1994 to introduce a risk mark and provide for a first-to-file system for trademark registration. Before 1st September 1983, prior to the enforcement of the TMA trademark protection in Malaysia was governed by 3 separate ordinances, which is first the Trademark Ordinance 1950, the Trademark Ordinance of Sabah, and the Trademark Ordinance of Sarawak, which have all been repealed by the TMA. The TMA and the TMR are administered by the Intellectual Property Corporation of Malaysia. Intellectual Property Corporation of Malaysia, MyIPO, also known as MyIPO, is an agency under the jurisdiction of the Ministry of Domestic Trade, Cooperative and Consumerism, which is responsible for the development and management of intellectual property system in Malaysia. So, definition of trademark. Trademark is a word, phrase, symbol, or design that help distinguish the goods or services from the competitors in the trade and may include numerous things such as signatures, name, labels, heading, and etc. The symbols commonly associated with trademark are in the bracket R and in the bracket TM for trademark. Moreover, almost anything can be a trademark if it indicates the source of your goods and service. For an example, the Golden Arch of McDonald's, which is letter M, are design that is registered trademark. You can see the example below.
Assalamualaikum to Madam Jana. Before I start, let me introduce myself. My name is Aida Kasrina binti Azahar and my metric number is DIL192009. In my presentation, I would like to talk about protection under Trademark Act 1976. So I will start off by the registration of trademark, since Alia Najwa has explained the introduction and definition of trademark in Malaysia. As we can see on the screen, any person that use or intend to use a mark will apply registration under Section 25, Clause 1 of the Trademark Act 1976. Meanwhile, under Section 10, Clause 1 of the Trademark Act 1976 states, trademark can be registerable if they contain or consist of at least one of the following, which are A. The presence of a person or entity represented a special or particular manner. B. The applicant's signature. C. Invented words. D. A word with no direct reference to the character or quality of goods or services, which is not geographical name or surname according to its general meaning, or a distinctive marker if there's a name, signature, or word which is not described in paragraph A, B, C, or D of subsection clause 1 is not registerable unless it is by evidence shown to be distinctive. Moreover, under Section 14 Clause 1 of the Trademark Act 1976 mentions types of a mark that is prohibited from being registered. Marks are not registerable if the use of which is likely to deceive or cause confusion to the public or would be contrary to law. Second, if it contains or comprises any scandalous or offensive matter or would otherwise not be entitled to protection by any court of law. Third, if it contains a matter which in the opinion of the registrar is or might be prejudicial to the interest or security of the nation. Fourth, if it's identical with or so nearly resembles a mark which is well known in Malaysia for the same goods or services of another proprietor. Fifth, if it's well known and registered in Malaysia for goods or services not same as those in respects of which registration is applied for, provided that the use of the mark in relation to those goods or services would indicate a connection between those goods or services and the proprietor of the well-known mark, and the interests of the proprietor of the well-known mark are likely to be damaged by such use. 6. If its contents or consists of a geographical indication with respect to goods not originating in the territory indicated, if use of the indication in the marks for such goods in Malaysia is of such a nature as to mislead the public as to the true place of origins of the goods. 7. If it's a mark for wines which contains or consists of geographical indication identifying wines, or is a mark for spirits which contains or consists of a geographical indication identifying spirits not originating in the place indicated by geographical indication in question. Next, how long does the registration last? Well, under Section 32 of the Trademark Act 1976 states that the registration of a trademark shall be for a period of 10 years but may be renewed from time to time in accordance with this Act. Registration of trademark is territorial based, so if you registered the mark in Malaysia, your mark is only protected in Malaysia only. There is no unitary registration system to cover the entire world. However, certification marks are registerable in Malaysia. Section 52, Clause 2 of the Trademark Act 1976 states, by reason the use of the trademark or any other circumstances, the mark is in fact capable of distinguishing in relation to the goods or services in question. That's all from me. Thank you. Now I will pass to next presenter, Sharina.
Assalamualaikum and good afternoon to Madam Fatiha and also my fellow friends. So today I am going to present about the rights of trademark and also the infringement of trademark. So I will start off with the rights of trademark. So most frequent questions being asked is, can other people use my trademark once I have registered it? So the answer have been laid down under the section 35 subsection 1 of Trademark Act 1976. where if it is valid, then it was given to the person the exclusive right to the use of the trademark. However, it was subject to certain conditions, amendment, modifications, and limitations of those trademarks being used. Next question being asked is, can trademark rights be established without registrations? The answer is yes. In our country, Malaysia, the first user of a trademark is the common law proprietor of the said trademark. The further explanation can be seen under the case of Besuma Sports that were had, and also the Majlis Sukan Negara. So we'll move on to the infringement of a trademark. The question here is, what is the remedy available under the Trademark Act 1976 for the registered proprietor of a mark? So the remedy for a registered proprietor is available under the Section 38 of the Trademark Act 1976. So the infringement here means a person who is not the one who registered it have used the mark which is identical or nearly similar to the one that have been registered to deceive or cause confusions in the course of trade in relation to goods or services. So in order to comment an actions against the infringer, a mode of application shall be by the writs of summons by the one who have registered it. If the infringer is able to show that they are the first user of the said mark, in the common law, they are entitled to have the mark removed by the way of court order. So in conclusion, we can conclude that registrations of a trademark is necessary for protections of the mark and also at the state of the company. So for if you have any company or a trademark yourself, you have to register it because the registrations guarantees that you have the sole and exclusive right of the said mark to yourself and not to others. That's all from me and that's all from us. Thank you.
It's the end of our presentation. Is there any question? That's all from us. Thank you.